There is no question that judges have immunity, and many are guilty of much wrongdoings in our courts. Bad and improper decisions, day in and day out, jeopardize the fate of many honest Americans. When a litigant has been wrongfully prosecuted, there is rarely effective recourse, nor are our constitutional right to a speedy trial available. My guest has spent several years opening doors most would not have tried these areas. He is considered an expert on all legal investigations outside the courts or within. We hope his investigations provide some security in the future for a just America. My guest is Dr. Richard Cordera, who's a lawyer and is also a doctorate, right? So, okay.
A doctor of law.
Okay, doctor of law. Maybe you can just tell us a little bit about your background so I can introduce it to the audience.
Sure. Well, first of all, I would like to thank you for inviting me here and for having the opportunity to address your audience. As to my background, I studied law in France, in La Sorbonne. I studied commercial and monetary law, and then I went to the University of Cambridge in England, and I got my PhD there on banking law. And I came to the U.S. I'm an American citizen. I came back to the U.S. And got admitted to the Second Circuit here in the state of New York. So I am a lawyer in New York. I also have a master in business administration from the University of Michigan. And I specialized there in the use of telecommunication devices to improve the productivity of companies. But that is very useful in any investigation. At the very least, that you know the infrastructure that you can use to conduct an investigation. What you said up now about the immunity of judges is very interesting, because there are many people that have the impression that lawyers, particularly in the federal jurisdiction, which is the jurisdiction in which I specialized, have any immunity granted by the Constitution, and that is not the case at all. The Constitution, on the contrary, states that all officers can be impeached, and that includes judges. It is simply a judge-made rule in self-interest that provides for judicial immunity.
So when we hear about judicial immunity, that a judge has immunity, it's not necessarily a law that applies.
No.
It's not a rule of law.
No, that is not a
so
rule.
we can claim against that now.
Well, the point is that you have to claim that in front of judges.
Yeah.
And the wrongdoing that you mentioned comes because judges are going to protect each other. So the immunity is self-granted. Is something that they have abrogated to themselves, because there is no outside force that will
applied against them, right?
Exactly.
Yes.
So you have judges that are appointed for life in the federal jurisdiction, the only jurisdiction that provides life appointment. And they're going to spend 5, 10, 15, 20 years or even more together, working together. They have no interest whatsoever in accusing. Exactly.
Yeah.
They are going to be spending the rest of their professional life with people that could turn around and say, when I was in a predicament, you turned against me. Now we are all going to turn against you because you're a traitor to the class of judges. The judges themselves protect each other.
Sure.
Now, the other avenue that you have is to go to Congress, but Congress is formed of the people that recommended the nomination of these people that became judges.
Is that like we were talking before about legislation that takes forever and that you can't legislate that, and there's no place to go with that? You can't legislate the judge's behavior, character, or licensure, time in office, or anything like that?
Exactly, yes. It is very difficult for the legislatures to turn against their own people that they recommended or that they campaigned for, that they endorsed, and in Congress that they confirmed. So
that's a natural good buddies club.
Exactly.
Yeah.
And also because of something very important, which is that presidents and also members of Congress get elected on a legislative agenda. They have an interest in having that agenda passed. Now, if they were to declare themselves enemies of judges because they vigorously try to expose their wrongdoing, the judges could retaliate. And they could say, well, that law that you passed is unconstitutional. So put yourself in the position of a judge that has the possibility of retaliating against a member of Congress or the president. And now you put yourself in the position of that member of Congress and say, am I going to risk my legislative agenda just because Johnny says that a judge did something wrong? Of course not. They're going to say, well, tough luck. You have to fend for yourself, whether in the courts, which is hopeless, or just on your own in the press. And the press is not going to take the case of one individual to expose that wrongdoing, because they too have the fear of being retaliated
This
against.
is a daunting reality for not only the people who litigants, but also for people who suffer from a loss of a decision that can't be recovered. You have no place to go.
Exactly.
And they have all of the controls in place to keep themselves there. So that's kind of an immunity.
Yes, but it is simply self-granted, or otherwise an immunity that results for self-interest. Everybody looks at their own interest. But, I mean, that is not evil. We all do that.
And yeah, I was going to say, there's many clubs and many people who will do that. They'll protect themselves. So in this case, though, you're responsible for the lives and the justice of others, and they still can hold a bad decision and not be held accountable for it.
Exactly, and that is the word that is key. It is the lack of accountability of federal judges that allow them to engage in wrongdoing. Now, the wrongdoing can be because they make decisions that take the law in disregard. But also, there is a different type of wrongdoing, which is when they simply use the information that comes to them for their own benefit. And then they engage in this type of wrongdoing that everybody would identify as such. So there is a big difference when you attack a judge by saying that his decision was wrong, because that involves judicial discretion. And it is very difficult to get the media or even an individual to say, yeah, I agree with that, it was a bad decision. So what? You have to appeal. You have to go through the different instances.
With a 2% or a 1% success ratio on appeal in most cases.
Yes.
You have another daunting reality.
And that is if your case is accepted, because in the Supreme
Sure,
Court,
yeah.
less than one case in 100 gets heard by...
That's what I was saying,
by
1 or 2%, yeah.
Exactly. So the other type of wrongdoing is the type of wrongdoing that everybody would understand as such, and that involves, for the most part, financial wrongdoing. When a judge uses the information that comes to him
To benefit himself?
to benefit himself, or otherwise to benefit his cronies. And that is the word that there was used in the 1970s in the bankruptcy area.
Cronies.
Cronies.
Right, yes.
Yeah. Cronism. That was the word there, because bankruptcy judges at that time could appoint the trustee in bankruptcy. And that allowed, obviously, for a pay-by-play, where the trustees had to get on the good side of the judge in order to be appointed. Now the system is different, because the judges do not appoint bankruptcy trustees. But nevertheless, they have still the same power of removing them. And when a bankruptcy judge removes a trustee from one single case, that trustee is removed from all cases.
We've heard of that situation with trustees taking major advantages and taking large amounts of money as an advantage in those cases.
Exactly.
Am I right that that
Yes.
goes on? That's
Yes,
it's
yes.
fairly common.
That is
Why hasn't anyone been successful in exposing that?
because you would have to expose it in front of judges, and the judges are the beneficiaries of that relationship between them and the trustees. In the federal judiciary in 2011, the amount of money that bankruptcy judges had to determine whether it would go to the creditors or it would stay with the debtors was $373 billion.
Wow.
Now, when you have that amount of money and you have the power to exercise your discretion as to who is going to get that money, and you know that you are unaccountable, that nobody is going to remove you, then you have a big problem, because you have a motive for those people to abuse their power. So now what we would like that to do, obviously, is to try to expose the wrongdoing of judges. And what I did in a study that perhaps you can provide your audience with the title is to identify the motive, the opportunity, and the means of federal judges to be unaccountable and then to abuse their discretion in order to benefit themselves from their position, knowing that nobody's going to
What are you referring to in terms of identifying a motive? I don't. The
well,
motive would be
the motive,
self-interest.
exactly, but you have to state that with evidence. You cannot just allege that people are evil.
So you're looking for
For the evidence that is there on how the money is disposed of.
can you do this case by case, or can you have to multiply cases and gather them all together and like a class action would?
Well, no, you simply used, for example, the amount of money that the judges determined by exercising their discretion. That gives them the opportunity. The means would be their misuse of discretionary power to decide who gets the money. And then the motive would be to get that money for themselves or for the people in their circle. And the people in their circle is not just judges, it is also the trustees, the lawyers,
Sure.
the accountants.
My God, this is unbelievable.
Yeah.
It seems like it's a safe haven for wrongdoing, this
Exactly.
federal judiciary.
Yes, that is the point. But now, how to expose that? And we just mentioned that there are two kinds of wrongdoing. One is within the judiciary itself. That is a hopeless avenue of trying to expose a wrongdoing.
That's unfortunate.
Yeah. The other way is to try to expose a wrongdoing that everybody would understand that it is such, that it is not just exercise of judicial discretion, that it is wrongdoing because for everybody it is. And that is, in the main part, financial wrongdoing. When those judges have abused their discretion to get the money for themselves or not to declare the amount of money that they have, you have their financial wrongdoing. In the federal judiciary, as in other parts of the federal government, you have a law that compels judges to file a mandatory financial disclosure report.
Right.
Now, you can get a hold of 7 years worth of those reports. And if you analyze them, you see that they don't make any sense whatsoever. So you don't have to be an accountant to realize that people that earned around $200,000 a year, that's the salary of judges, they cannot possibly have so little amount of money. Where did that money go?
I see.
So,
how did they suddenly get to that amount of volume of dollars?
yes.
When they were you're at a low
how
level, yeah.
How they declare so little when they earned more than 4 times
Right.
what the average American
Right.
household earns.
Right.
So what I was trying to do in the study is to try to provide a strategy for exposing that wrongdoing that everybody would recognize, which is fundamentally financial wrongdoing. Now,
I'm not sure I should mention, we have some information about some judges who have gone above the law in some respects. So, I mean, off the air, I'd like to share that with you. I don't know if I could share that with you now, but...
Yeah, well, we have one that is well known. In 2009, President Obama nominated, at that time, Judge Sotomayor.
Okay, yeah.
And you had a series of articles published by the New York Times, the Washington Post, and Politico suspecting concealment of assets by Judge Sotomayor. Now, that was done because they were using precisely those reports that Judge Sotomayor, as well as her colleagues, had to file, which are publicly filed. They are available. And also, they used the documents that she had to submit to the Senate Committee on Judicial Nominations.
Sure.
So they were using information that she had provided. And they suspected the concealment of assets precisely because if you earn so much money over the years, then you have to show something for it, some assets.
And that didn't happen.
It didn't happen. And I have in my study a table listing all the assets that she declared and all the liabilities that she declared. So this is not something fanciful that you just pull out of the air. It is simply tabulating what she declared.
Why didn't anybody else pick that up? Why wasn't that?
Well, there is an interesting question, and you have to think that initially the New York Times, the Washington Post, and Politico came out with this suspicion of concealment of assets by then Judge Sotomayor. And then all of a sudden they just dropped the story. And that story, if pursued, could have led to...
It smells of political preference.
Well, perhaps not political preference, from on the part of the newspapers, whether there was a quid pro quo. But now the point is how to direct the attention of investigative journalists to pick up that story that has the credibility.
That's why I cannot figure out why that hasn't been done.
Exactly. It is very difficult. And one of the reasons is because of the fear of retaliation. If you are a newspaper...
So in that case, we're not in America. For just that moment in time, that snapshot of looking at this record that Sotomayor may or may not have, we're not Americans at that point. We can't do anything about it. We don't have a First Amendment right to impose a state anything about it.
We can investigate them, and there is a group that is called the International Consortium of Investigative Journalists. They have their headquarters in Washington, D.C. They received almost 17 months ago, so by the end of 2011, a hard drive that contained 2.5 million financial documents concerning assets in offshore entities, whether they were banks or trusts. And they spent 15 months investigating those documents that are known as offshore leaks, because they were leaked anonymously to them. So now, after these 15 months investigation, they have acquired a unique expertise in follow the money investigations. And the strategy that I am trying to propose to you and to your audience is that we should try to convince this group of international investigative journalists to use their expertise to expose the wrongdoing of federal judges. And once a sufficient amount of exposure of the wrongdoing came to light, that would outrage the public, the national public.
Sure, the term we use regarding how the sentiment is that I get out of the conversation you give me now is absolute power corrupts absolutely. There's no way to get into that without suffering any kind of penalty yourself. So the power that one has supersedes any other opportunity to intervene, seems like.
Well, the opportunity has presented itself up now because, as I said, this is an international consortium of investigative journalists, which means that not all of them are here in the U.S. If they
That's why I say international. How many people are you talking about, basically?
Well, according to their own reports, 87 investigative journalists.
Internationally,
yeah, but
that's pretty significant.
Well,
and when you think about them, how many people would do that?
No, and the papers and the media outlets for which they work. They work for The Guardian in England, for Le Monde in France, for the Süddeutsche Zeitung in Germany. So these are people that work on for the top newspapers and media outlets in countries around the world.
Is there any in Switzerland? Shouldn't there be?
There could be, yes. They don't list all the papers, but nevertheless, if they wanted, they could publish the news outside of the U.S. But now with the internet, that is meaningless. You know,
right,
you can be here in the U.S. and you can investigate the whereabouts of the assets of then Judge Sotomayor and now Justice Sotomayor. And if you simply exposed enough to make it credible that there was a concealment, that would outrage the national public.
But it would be sort of along the lines of what's just recently regarding the IRS has outraged the public. Exactly.
That is the point. In less than 2 weeks now, this whole system of some type of impropriety. We cannot say that it was a conspiracy, but it was improper to do that.
Certainly,
okay?
it was impropriety. Yes.
But for the Tea Party groups that had to wait even 2 years to try to get their
501c3,
yes.
Sure, yeah. Mm-hmm.
In less than 2 weeks, the whole thing has exploded, and
right.
now they know that they are not alone. That all the other people that were applying for tax exemption, they were in the same situation.
Sure.
And that is what you can get here. If you get enough of this information of the whereabouts of the assets of Justice Sotomayor at the time and now Justice Sotomayor, and you make it credible the same way that the New York Times, the Washington Post, and Politico started to do, and then you would get the national public outrage that would give an incentive to the rest of the media to investigate.
Sure, to put forward, yeah.
You would get the same reaction as with the IRS scandal.
Well, this is the first I'm hearing about that particular scandal, the Sotomayor. I'm sure
that
information is available.
In 2009.
Sure. But I mean, what I meant by that is that it didn't continue.
Exactly. Yeah, it stopped all of a sudden without any explanation.
Well, that's where my concern lies, right there. How did that happen? How did it?
Well,
some quid pro quo someplace, right?
Perhaps, yes. But now we can use that information to approach this group, and I have provided you with their contact information. But also, if you just Google offshore leaks.
Right.
Then you will get to their website.
On tax evasion and money laundering, you use that terms.
Yes, that's part of the 21 to 32 trillion dollars that are involved in offshore accounts. This is simply beyond the scope of the imagination because you have to consider that the national debt of the U.S. is less than 17 trillion. And we are talking here about 21 to 32 trillion dollars.
It's unbelievable.
Yes. So right now, that is the strategy to get the people that have come here that have told you about their problems in the state judiciary. In the state judiciary, they will have the same problems of interest within the judiciary, interest between the judiciary and the legislative branch, protecting judges. You're not going to get anywhere that way. You have to try to get the attention of the national public, and once you do that, and you force the politicians, lest they be outvoted or not elected, to investigate this wrongdoing by judges, then you can expose both their financial wrongdoing as well as their non-financial wrongdoing, and then you create a precedent that can be used by people in the states. And that is what then would set this kind of judicial investigation rolling. But first you have to go to the federal judiciary, try to get the expert of the International Consortium of Investigative Journalists to use their expertise to investigate the whereabouts.
That seems possible. I mean, that seems like it's the right thing to do. Get a hold of this organization, going forward, and see what you can do to highlight. But my only curious element about what we've spoke about so far in the remaining minute or two we have left is how do you tie in a case, and how can you stop the world on that case and get the you want to circle the wagons, get all the information from the investigative journalists first before you make the presentation.
Right now, the effort is just to get the attention of this consortium in Washington to investigate the case of Justice Sotomayor. And once they use their unique expertise in follow-the-money investigations, and they exposed some of the assets that she has, or in the process they investigate where other judges have assets, then you can get the national public outraged, and that will attract the attention of other media outlets to do the investigation the same way they have done in the case of the IRS scandal or the Benghazi scandal.
You've done a great job, Dr. Richard Cordera, in explaining this, and I hope that with our effort here, that maybe we can begin a process of making something work in the direction you're talking about. This is something I think needs to be done. Societal and political trends are rapidly breaking down our social order, once was the cornerstone of our great American culture. At FIT, we know you cannot get this information on your own, so of course we'll present it to you every single week. My name is Chris DiMaggio, and I want to thank you very much for watching FIT TV, and we'll see you again next week.